Or fine, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You're also charged with theft, a Class A misdemeanor where you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Law enforcement officer spoke with the complaining witness who stated that on April 2nd, 2025, he parked his truck in his company's parking lot, locked the truck, and when he returned the next day, his tailgate was missing. An employee of the complaining witness searched Facebook Marketplace and found a tailgate that matched the complaining witness's stolen tailgate and had recently been published. The law enforcement officer executed a sting operation to purchase the tailgate from the defendant, the seller, on Facebook Marketplace. He paid the defendant $140 for the tailgate. The defendant was subsequently arrested. The complaining witness stated the price to replace the tailgate was $1,117.65. The defendant stated he buys the tailgates from a friend for $75 and resells them for typically $300 to $400.
We have him taking the actual tailgate, right?
Yes, Your Honor, that's what it says. Well, it has him as the seller of the tailgate.
Yeah, I didn't take the Your Honor.
Stop. Don't say anything. You have the right to remain silent. Exercise that right.
Yes, Your Honor, it has him as the seller and that it was recently published 2 hours ago on Facebook Marketplace. But those are the facts as far as the dim summary goes.
It says here that this defendant did then and there unlawfully appropriate by acquiring or otherwise exercising control over property, namely a tailgate owned by Jonathan Smith. Did he take the actual tailgate?
Your Honor, there are no facts alleged in the DIMS that he knowingly took the actual tailgate. However, the tailgate was in his possession and under his control.
Sure.
And he was the seller on Facebook Marketplace. There's no information in the DIMS, though, that represents that he was the actual individual that stole the tailgate. In fact, when the officers interview him, he says that a friend, he buys the tailgates from a friend and then resells them on Facebook Marketplace.
Are we to assume that he knows that they're stolen? You know, he's charged with theft, right?
Yes,
It's a specific intent crime. So if he's selling stolen property, somehow there has to be evidence that he knows that it's stolen. How do we know that he knows it's stolen? We don't operate on hunches.
Your Honor, there is also an allegation, or it's alleged in the DIMS that the defendant told the law enforcement officer that he was aware the tailgate was stolen.
Well, there you go. Okay.
Thank you. It's my fault.
Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward in the theft case. What about the failure to stop and give information?
Better to stop and give information.
Let's see. We need to do probable cause on that one as well, please.
Good, Your Honor.
Yep.
The law enforcement officer was following up on this case in the original report. The defendant's vehicle struck a metal gate at an apartment complex. A witness looked out her window and saw the suspect vehicle and photographed the driver and passenger as they exited the vehicle. Law enforcement officers ran the plates and had the vehicle and owner information. The law enforcement officer later observed the defendant's vehicle in front of the residence. The vehicle had significant damage to the hood. The law enforcement officer made contact with the driver, the defendant. The defendant was ID'd to be the vehicle owner. The defendant stated he loaned his vehicle to an acquaintance he only knows through Instagram. The defendant showed the law enforcement officer the man's Instagram named Go Get a Veil. The defendant claimed that this man needed to borrow the car to pick up a girl. The defendant stated he would obtain the man's real name and provide it to the law enforcement officer by the end of the day. The law enforcement officer was not contacted by the defendant again. The law enforcement officer took a still shot on his body-worn camera of the defendant during the conversation. The law enforcement officer later compared the photos and saw the defendant was the same as the photo from the reportee. The law enforcement officer attempted to contact the defendant and could not. The apartment complex's estimated damages are $2,000.
Got it. Mr. Aguilar, I'm going to find that there's sufficient probable cause to go forward on both of your cases. Can you tell me if he has a license to drive, please? Texas driver license.
John, can you check that on Aguilar?
Don't. I know that you are itching to say stuff. Don't.
Oh, no,
You
no,
have
sir.
the right to remain silent. Exercise. I've got a bunch of DAs here. Whatever you say, they're going to use it against you. So
Yes, sir.
just now's not the time to fight your case. You will have the opportunity to fight it. Just now's not the time. I want you to understand, Mr. Aguilar, I will do everything in my power to protect my city at all costs, including property. And if I find that you're a danger to my city, I'm going to lock you up and I'm going to make your bond so high, you'll have hair falling out.
Yes,
Do
Your
you
Honor.
understand?
Yes, Your Honor.
Tell Your Honor.
Tell me what time of night was, do we know the theft of the tailgate? Was it in the middle of the night?
So it was reported around 5 p.m. That's the only information we have, Your Honor.
Okay. I'm ordering you as a condition of your bond not to pick up any new cases, not to have any contact with the complaining witness in the theft case, not to go within 200 feet of where they live or where they work. Do not pick up any new cases. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, and that is also a bond condition. If I find that you're driving without car insurance, likewise, you will go to jail. That's it. If I end up revoking your bonds for one thing or the other, they're probably going to end up around 10, maybe 15,000. And if you don't have anyone to pony up that kind of money, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we are going to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. After that, you'll be free to go. Don't be a danger to my city. Do you understand me?
I understand.
Come on. Good morning, Mr. Hissa.
Good morning.
Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor.
On March 26, 2025, in Harris County, Texas, an officer was dispatched to a vehicle accident. The complaining witness stated he was driving when he noticed the defendant was tailgating him in his truck. The complaining witness stated he brake checked the truck. The complaining witness stated he attempted to change lanes to let the defendant through. The complaining witness stated the truck went around him, got on the median, and then collided with the complaining witness's vehicle on the side. The complaining witness stated the defendant pulled ahead of him and turned to leave the scene. The complaining witness stated he followed the defendant and got in front of his truck to prevent him from leaving. The complaining witness and the defendant exited their vehicles. The complaining witness stated the defendant came up to his face and was yelling that the defendant was trying to find a good place to stop. The complaining witness stated the defendant got in his motor vehicle and left without providing his driver's license or insurance. The complaining witness stated he did not want to press charges. The complaining witness estimated damages to be $500. An officer ran the plate provided by the complaining witness. There was a driver's license attached to the plate. The officers ran the attached driver's license and got a return photo, and the complaining witness ID'd the defendant by this driver's license photo that the officer showed him.
Mr. Hitz, I'm going to find that there's sufficient probable cause to go forward with your case. You mind running his license, please?
Yes, Your
The city
Honor.
has a valid license. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If I find that you drive without either, or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer?
I think so. Yes.
Okay.
Yes.
We'll give you time. If you have any problems, just come back and talk, and then we can go further. If you need an appointed lawyer or anything, we can always have you fill out an application. So for now, I will have you go to Victoria, sign a reset. We will then have you take a seat in the jury box while I get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go. All right? Thanks. You're Mr. McQueen?
Mm-hmm.
It's not an answer.
Yes, sir.
Mr. McQueen, you're charged with indecent assault by contact with fluid. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yeah.
Your Honor.
Your Honor, if I may, I believe we already read probable cause,
Yeah.
and you found probable cause on this case. But
That's what I was about to say.
Is this an arraignment?
It was last Tuesday.
Oh, yes, Judge, we set a bond, 415. Oh, that's right. We did bond conditions and then let him go with the bonding company to post a bond. So this is his arrangement.
Ah, got it. Okay, so what we'll do is, do you have a lawyer?
Yeah. But her mother just died, so she's not here today. So she said she's been trying to call whoever answers the phone to tell them.
To set him THA, because this is his.
Yeah, that's okay. Yeah, all right. So we're gonna give you more time regardless, since she's not here, or he. We'll just have you sign a reset and then we'll have you get going, all right? Okay. Here.
Yeah, she's there.
Ms. Crawford, come up.
So if you could just give her another week, she'd probably get insurance and we'll get the
I
contract.
mean, it's 200 days now.
Yes, we just, it's tough for her, but I think she can get insurance, Judge. So,
Hi, good morning.
This is extremely old. It's 200 days.
Yeah.
that's the only thing
Just
left.
to even get the contract?
No, everything's in. They just need either, well, she's gonna get the insurance. That's the only thing that's.
What about the interlock? She's gonna have to pay for the interlock. She's gonna have to pay the DA fee.
Yeah.
Yeah, she knows, she understands that, but we have to get the contract. But can you do that within all 2 weeks? You remember it's
It's 200 days. I'm not doing 2 weeks. Dude.
1 week?
I will give you a week if you don't have it done. But we can't just keep resetting it in hopes that it happens. I mean, I
Right.
have to put a time limit on it.
I'm just now hearing
Yeah.
about this today. Like, I'm just trying to get it done. I don't.
No, the insurance I was flagged, Judge, so,
Yeah.
I mean, it was ready until I followed up with
You
Brenda.
need to get everything finalized and done. Just stay in contact with John so you can met.
Okay.
Okay. Yeah. And then the other one, Judge, is Mr. Nyla.
Answer yes or no, sir, to the judge. And speak loudly.
Stay forth. If you ever test positive for anything of this nature, I'm going to put you in jail. Do you understand? You are not to consume alcohol, illegal drugs, unprescribed controlled medications, and I'm going to test you weekly to make sure that you're not using. Do you understand? The next time you test positive, you stay with me. Okay? He ran with testing once a week, please. For him. All right, take a seat for me, sir. Thank you.
You reset, judge.
Yeah, do a reset, but he's gonna have to come once a week to get tested.
Yes, sir.
I'm gonna do a normal
Yes.
setting. Okay? Yes, ma'am.
Judge, we have a panel outside, just a heads up.
Okay, do this and then we'll go. All right. Good morning, Ms. Davis.
Good morning.
Ma'am, you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're making a lifetime decision today where this assault is going on your record and it will be there for the rest of your life. You can never take it off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
I'm facing 90 days.
If you pick up any more cases,
Oh, yes, sir.
facing a minimum of 90 days in jail.
Yes, sir.
You're giving up the right to is this on doctor?
It's on the
Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You understand?
I do understand
This
that.
isn't like Target where you don't like it. Oh man, this is hurting. You can return it. No, once you plead guilty, it stays with you forever. You never change it. If you're not guilty, don't plead guilty. It's just that simple, really. Don't, because you'll always live with regret.
Sir, I was assaulted first.
I can talk to you about that case. Right? You're telling me that it's self-defense, then
A trial today. She's gonna show up.
She won't.
guys, I'm happy to give you more time to discuss it. Just, it's probably not best here. I live stream, so.
We will for tomorrow, Your Honor.
Sure.
Okay, thank you, sir.
All right, ladies and gentlemen, we are about to bring in a panel. We're about to start voir dire. I need you no talking whatsoever. If you need to talk, go outside. If you want to use your cell phone, go outside. Come on, person, come on. Mr. Muhammad,
How you doing, sir?
you're charged with failure to comply with, basically FSGI, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Thank you, Your Honor. On March 22nd, 2025, in Harris County, Texas, the complaining witness went to the police station to make a report for someone that struck her vehicle and failed to stop and give information. On March 24th, 2025, the officer reviewed body-worn camera where the complaining witness stated that while she was at a soccer game, someone struck her parked vehicle. The complaining witness stated that another witness left a note, and that witness observed the defendant strike the complaining witness's vehicle and leave without stopping and giving information. The witness stated the defendant was the coach of the opposing soccer team. The complaining witness stated that they talked to the defendant, but the defendant has failed to provide their insurance information. The officer met with the witness who viewed the accident and administered a photo array. The officer observed vehicle damage from the defendant and the complaining witness consistent with complaining witness and witnesses' accounts of events. The officer observed text of the complaining witness communicating with the defendant. In those texts, the officer observed the defendant state he is responsible for the crash and he has no problem paying for the expenses out of pocket. The complaining witness obtained a written estimate of cost of repair to her vehicle of $1,975.78.
Okay. Mr. Muhammad, I'm going to find that there's sufficient probable cause to go forward with the case. Does he have a license? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
Yes, Judge.
I'm also ordering you not to go back to the soccer field. Do you understand? If I find that you pick up a new case, if you go back, I will revoke your bond, put you in jail. No more.
Judge, may I? Is there any way we just do no contact with this person? Because in this club soccer world, there's only like 2 to 3 fields that they play on. My daughter's played Albion, and there's only like 3 parks that they play out. So can we just?
It's to happen again. And
I understand. Can we do a no contact so that he's not around that person because he's the head coach of the soccer team? And we're going to get this taken care of pretty quick. I think they agreed that if he pays restitution, they're fine with it.
how is it going to be possible if they're still playing soccer that it's going to?
I think he can avoid them. These parks are big. There's Dice, Zuby Park.
Yeah, sure.
Yeah, go ahead. Go ahead.
First of all, sir, I've never had contact with the woman who claimed these claims. That's one. Second of all, I never left the scene because I had to.
I'm not going to argue with.
No, of course I understand.
We're not arguing the case.
Sir, sorry. Yes, I'm just trying to clarify that there's no contact between me and the or whoever's making the complaint at this moment. I've never had contact with her in my life, so there's no reason for any non-contact going forward, as I said.
Before he's allowed to drive, I want proof that he's got liability insurance, and I don't want you to have contact with the complaining witness. If I find that you get into another accident, if you're a danger to my city, I'm going to lock you up. Do you understand, Mr. Muhammad? Okay.
Thank you, Judge.
All right. We need to put bond conditions. We need to show proof to pretrial that he's got insurance, and then we'll allow him to drive.
Thank you,
Yes,
Judge.
sir.
You mind filing those conditions, please?
Yes, Your Honor.
Thanks.
June 24th, we include it.
Okay. All accounted for? All right, everyone please be seated. Good morning, everybody. Thank you so very much for coming. My name is David Fleischer. I am the judge here of Harris County Criminal Court at Law number 5. We are but one of 16 county criminal courts here in Houston. I'm going to go through the top because I don't know what you know. I don't know what you've heard. I don't know what anybody's been told to you. So I'm going to go as if you guys don't know any. So what are we? We are a criminal court. There are 2 types of criminal courts, actually 3 types. There are district courts that handle felonies. There are county criminal courts that handle Class B and Class A misdemeanors. And then there are municipal/JP courts that handle Class C. If you ever get a speeding ticket, if you get, believe it or not, a Class C assault or something of this nature, you will go to municipal court. Now, Houston, Harris County is so big that we can't just have a municipal court. We have to have outliers all over the city because, I mean, really, from one part of Houston to the other, it takes you 2 to 2.5 hours. And that's probably without traffic. Because of that, we have justice of the peace that are scattered everywhere that handle Class C cases. Now, what are Class C? Those are the types of cases that are punishable by up to a $500 fine. We here in county criminal court handle Class B and Class A misdemeanors. So a Class B is something that's punishable by up to 180 days in jail and or a $2,000 fine. And a Class A, which is the worst of the misdemeanors, are punishable by up to a year in jail and or a $4,000 fine. We have 16 county courts, and then there are 22 district. Actually, there may be more now. Did they add more district courts?
They did.
Yeah. Business is so good down here that they have to add more, which is not a good thing, right? I mean, we try to stop as much as we can, but it just happens sometimes, right? So they've had to add more district courts just because of the number of cases that are they're just popping up. I know that you don't want to be here. I know it's a burden to you. I would rather be playing Fortnite at home too. So I'm sorry to drag you down here. Really, I am. But I need you. Statistically speaking, we live in what, 3 million people? 5% of those upon call, 7% of people who are called upon jury duty actually show up. Do you realize that? It's just abysmal. So I'm so proud of you for coming and doing your civic duty. I really, really thank you. And really, if we didn't have you, it would be complete chaos, because how would anything function? So really pat yourselves on the back, and for those who are selected, you're going to get a whopping $40 a day and lunch. So thank you so very much for coming. We're here for a trial today, as you very well may figure out. It's a DWI, and I anticipate this case to last for 2 days, today and tomorrow. Is there anyone that cannot be here tomorrow for any reason whatsoever? They've got plane tickets, a doctor's appointment that they've made for months. It's okay. We bring a lot of you guys because I anticipate there are going to be issues. What I really, really don't want is to impanel a juror and then, I can't make it tomorrow. It's okay. Anyone that can't be here tomorrow? And please, when you answer up, please do so by your juror number. Juror number 15. No can do tomorrow. Not just because I've got I just don't want to come, or I've got.
Cancel the appointment. I've got a back issue and the doctor has me scheduled for
I'm okay with
That's
it.
it. I can
Okay,
cancel it.
not a problem, really. I'm happy that you're here. We try to accommodate as many people as we can. Is there anyone here that doesn't speak English or doesn't understand English very well? It's okay. Anyone. I'll tell you that no matter how many times we do this, I still get jitters in my tummy because I'm not a very good, orator or speaker. So if I fumble my words, I'm sorry. It's a serious case. DWI is something we take here very, very seriously. I don't think that any of the people here disagree about the law. Well, they disagree about whether the law was broken. And that's why we have trials, so that people can listen and make a judgment call. We're not asking any of you to split the atom, do Pythagoras' theorem. All we want you to do is listen and make a judgment call. Really, you in your gut will know if you hear someone testifying, whether they're in left field or outer space, or they're just completely wacko, or whether they know what they're talking about. It's just common sense. Is there anyone here that has some kind of experience that they don't think that they'd be able to sit for a DWI trial? You know what? Let's do this. I'm going to let the lawyers get into it because I don't want to start questioning you here. They're each going to get about 20 to 30 minutes to ask you questions. Please let them know, because what we don't want is someone who already has a preconceived notion how things should go. All we want you to do is keep an open mind, leave everything at the door in the past, just come in, listen, and make a judgment call. I'm gonna first, before I let the lawyers talk, I'd like to introduce them to see if anyone knows anyone in any of the players here. State, will you please stand up and announce yourselves? Introduce yourselves.
Good morning, everyone. My name is John Denver. I represent the state.
Blaze jurisdiction, I represent the state of Texas.
Anyone recognize them? Okay, you may be seated. Defense.
Good morning, everybody. My name is Ray Vasquez. I'm representing Mr. Gomez. And assisting me today is Abel Izagiri.
Anybody recognize them? Okay, please be seated. Now, without further ado, I'm going to let you have the floor.
Big judge. All right. Good morning, everybody.
Morning.
So, like I said, my name is John Denver. I represent the state in this case. And like Judge said, it is a driving while intoxicated case. Let's get into it. All right. In this country, the defendant is innocent until proven what? Anybody can say it? Shut it out. Correct. I'm the only person that can do that. Nobody else has to do that. Defense doesn't have to do anything. It is completely our burden, the state's burden, to prove that to you. So to do that, we have to do a couple things. We have to show, beyond a reasonable doubt, that the defendant, on or about October 6, 2024, in Harris County, Texas, and like I said, the defendant, operated a motor vehicle in a public place while intoxicated. Right? Simple enough, pretty straightforward. We have to prove each and every one of those beyond a reasonable doubt. We'll talk about that in a little bit. But first I want to talk about intoxicated. What does intoxicated mean? Anybody have any ideas? You can just shut it out. Very good.
Under the influence.
Under the influence? All right. Anybody else? Drunk? Yeah. Pretty straightforward there. Now let's talk about the legal definition. So there's the legal definition is that intoxicated means the loss of the normal use of your mental faculties due to the introduction of alcohol or drugs, or that you've lost the normal use of your physical faculties due to the introduction of alcohol or drugs, or that you have a blood alcohol concentration of 0.08 or higher at the time of driving. Now, has anybody ever seen a drunk person?
Yes.
How did you know they were drunk?
Staggering.
Staggering. Okay, what else?
Slurred.
Slurs. All right.
Slurred speech.
Slurred speech. Anything else?
Talk a lot, smack.
Talk about smack.
Irritable.
Heard that one before. Irritable. That's another good one. All right. Did you know? Anybody who did you know what their blood alcohol concentration was?
No.
But you still knew they were drunk, right? So, and what's important to note here, I don't have to prove two of these. I only have to prove one of these, right? So if I show you one of them and I prove it beyond a reasonable doubt in your mind, right? That means I prove that element there in your state, right? But you don't always have necessarily 0.08, right? But like you just said, there's a whole lot of ways to be able to tell if somebody's drunk. So if I show you one of the other two, and I don't give you a blood alcohol concentration, then, but I do prove beyond a reasonable doubt, you still have to find the defendant guilty, or to show, or at least find that I proved that element was committed. If I prove all of my elements, right? Let's say for this hypothetical, I prove every single one of my elements beyond a reasonable doubt, including this one. But let's say I don't show you that they were above 0.08 at the time. Is there anybody here that would be incapable of finding the defendant guilty, even though I proved all of my elements here? Anybody? It's okay. Interesting. No? All right. All right. So got a little story for you. So these are my two granddads, right? Over here on the right, this is Mike. And on the left is Don, right? So Mike is a wine drinker, right? And as soon as he opens that bottle of wine, as soon as he smells it, he already starts getting giggly. You can look at him and he looks like he's drunk, right? Automatic. As soon as he sniffs that wine, as soon as he smells it. And then you have Don. Don is a whiskey drinker. And Don can drink all night long. And he never changes, right? He's the exact same, he's telling the exact same joke, acting the exact same way, and you never know he's drunk. So let's say that one night you're hanging out with Don, and you watched Don, and you watched him drink whiskey all night. And Don turns to you and he says, I'm a little hungry. Let's hop in the truck, run a Whataburger. I'll drive. Is there anybody here that's going to get in the truck with Don?
No.
Why not, though? He looks fine, doesn't he? You can't tell.
Yeah, but if you saw how much he was drinking, that's just a telltale sign that it wouldn't be in your best interest to
So-
ride with him.
Even though he might not look drunk, but you knew that he drank a lot.
Is he capable of driving?
So, well, for the purpose of this hypothetical, he's drank a lot. We're just going to say
My
that.
question is he capable of driving?
Well, for the purposes of this hypothetical, let's just stick with the fact that he's drank a lot of alcohol. But you don't know exactly how much.
The
So,
reason why I asked that question, I got one who can drink all day and still drive it smooth.
okay.
So that's why I asked the question.
So, if, let's say that uncle, would you get in the car with that uncle?
Maybe, maybe not.
Depends on the driver?
Yeah, depends on how I'm feeling that day.
Okay. All right. So let's say that I was able to show you that, a certain. Let's say that I proved beyond a reasonable doubt that the defendant was a harmless crime, right? But you thought, from whatever you saw, that the defendant was still capable of driving, like that uncle didn't drive at all.
Yeah.
Would you still be able to find the defendant guilty and follow the law that says that if I show you these above the .08, you've got to find the defendant guilty? If I prove to you beyond a reasonable doubt, you should still be able to find him guilty.
I'm going to object, Your Honor. It's a good one question.
Restate the question, please.
If I prove to you beyond a reasonable doubt that the defendant was above a .08
Mm-hmm.
and was intoxicated by the law, and I proved to you all my other elements beyond a reasonable doubt, would you still require me to prove that he was incapable of driving, like you were talking about, even though I proved all my elements beyond a reasonable doubt?
First of all, I recommend he stop driving.
But just a yes or no,
Yeah,
you'd be able to find him guilty,
yeah.
or you need me to prove more?
Well, I mean, his blood level was, what, 20? Yeah.
You'd be able to find him guilty?
Okay.
Still a commitment answer to the judge.
Please don't ask just these commitment issues. Ladies and gentlemen of the jury, remember, back in the old days, we didn't have all these things. There were no blood tests. There were no breath tests. There was no videos. With the advent of science, with new technology comes better aids, right? But at the end of the day, common sense dictates. You know what you see. You know what someone looks like when they're a particular way. Just use common sense, right? Everything else is just...
All right, let's move on with it. All right, so I talked a little bit about beyond reasonable doubt, but what does that mean, right? Surely there's a definition. Not so much. But what it is, I can tell you essentially what it doesn't, right? It does not mean beyond all doubt. It doesn't mean beyond a shadow of doubt. And it doesn't mean beyond a certain number of percent, right? 95% sure, we don't use that, right? You just have to base it on your common sense and your life experiences. Okay? So, for this next exercise, I'm going to show you a picture. And it's going to be blocked out. And then I'm going to go through each slide, and each slide is going to reveal a little bit more of the picture. Okay? So, once I get to a point where you see enough of the picture, where you think you know what it is, beyond reasonable doubt, I'm going to ask that you raise your jerk button. All right, has everybody got that? Anybody have any questions about that? Everybody good? All right. All right. Anybody know what this is? The whole picture, sorry. No? Anybody have any guesses? It's a place. All right, I can tell you that much. It's a place. Anybody know what place we're at? Just based off that little sliver? All right. Good. Anybody now? It's got a specific name. It's got a proper name. All right. Anybody now? Okay, but are you beyond reasonable doubt? Are you sure beyond reasonable doubt that is what you're saying?
Beyond reasonable doubt? Not yet.
Okay, all right. Just when we're beyond reasonable doubt, all right, everybody? All right. All right. Anybody now? All right, go ahead and raise your jerk card if you are good beyond a reasonable doubt. Raise them high, please. All right. Don't put your cards down now. All right. Who's left? If there's anybody left. All right. Now, anybody? Those still left? Okay. All right. So yes, it was Stonehenge. All right. It was a good guess. But you see, that's kind of how beyond reasonable doubt works, right? So when we went back here, here, you said you thought it was Stonehenge, but you weren't sure, right? Why weren't you sure? What was the feeling that you had?
Well, I've seen, a lot of pictures of Stonehenge. It look like there are some copies elsewhere.
Okay.
That are smaller scale.
So, but when we got to here, you saw that. And that's when you decided you thought, okay. So everybody can kind of see, right? I still don't have the full picture, right? There's a lot missing. Like you said, there's copies, there's other things elsewhere, right? But if I have enough of that picture, then I can still say that it's beyond reasonable doubt, even though I don't have everything that's there, right? And that's kind of how trials work. That's kind of how evidence works, right? There's might be some things that we're just not going to know. But it can still be beyond a reasonable doubt if I show you enough of that picture. Does that make sense, everybody? All right, so let's talk about evidence, right? We've already said it's a DW evidence. So, what kind of evidence do I expect to see in this case? Anybody? You can start anywhere. Crashed car. Crashed car, maybe.
Maybe a video of catching speeding.
Okay, what else?
Maybe an offense report.
Okay,
Like feeling sobriety test results.
okay.
Witnesses?
Eyewitnesses.
Eyewitnesses, okay. Anything else?
Blood alcohol test.
Okay. Anything else? Those are all good answers. Now, like we said, and we talked a lot about beyond reasonable doubt. And we've talked a lot about the illness. But is there anybody that would need a specific type of evidence in a DWI case, right? You said blood evidence. Is there anybody that would need a specific type of evidence before you could find the defendant guilty, even if I proved all of my elements beyond reasonable doubt?
If you hit someone,
You would need to know that evidence? Or
if you hit someone,
did he hit someone? If he didn't hit someone, would you be able to find him guilty? Even if I proved all my elements beyond reasonable doubt?
possibly,
Possibly.
yeah.
Okay. Anybody else need a specific type of evidence? You said you need to know the speed.
Right.
So,
Could have been people know the speed of traffic, you know, causing an ailment to drivers behind it.
okay, so if I didn't have what speed you just going, but I proved all of my elements beyond reasonable doubt, would you still be able to find him guilty?
Maybe.
Maybe, and I just yes or no, and I'll repeat that for the record. No, you would not be able to find him guilty, even if I proved all of my elements beyond reasonable doubt, because you didn't know what speed he was going. Thank you. Anybody else? Do number two.
I think I need a report for breathalyzer, all that.
Okay, so even if I prove to you, because we already talked about, remember back there, we talked about the definition of intoxication. Those are all ors. I only have to prove one of those two to meet that element, right? So you're saying that even though I proved my case beyond a reasonable doubt, if you don't see a blood alcohol test, you're not going to be able to find it.
Maybe a approach, Judge.
The alcohol.
Sure. Repeatedly trying to get them to commit to something, you know? Either rephrase it or, you know.
I can rephrase that question. I was trying to clarify exactly what you're saying. Wanted to get back to understand what I'm trying to do, which is that he's trying to get, you know, angry from you know, so I think it needs to be rephrased to where it's not exactly. Those seem like my questions to you, that would be my opinion.
Yeah, great. It is, if you're trying to commit them to something, like,
Sure.
all right.
She can hear, Judge.
Hmm?
She can hear.
Oh, okay. Just
Mike, with this commitment, why should this? Yeah. For some reason, I don't see a number. I can't find something.
just so you go, look, I've given all the elements. Can you find them?
Yeah. Okay, I just want to make sure.
Are you okay with that?
The can, I think it's good. I think
What would you suggest?
it could, but probably better than can.
Okay, so you should find you guilty if all my elements met. Just don't keep harping on it. Don't start going into the blood. Stay on the blood test. Then it gets into commandments. You might make the elements. Would you? All right.
All right, let's get back into this. So coming back to you. So even if I prove to you beyond a reasonable doubt that it was impossible, don't see specific type of evidence, could you still find the defendant guilty?
Jurors, all you need is common sense. If you see someone, they're falling down, urinating all over themselves, just use common sense. You know what someone is when they're not. Like I said, remember, in the old days, how did they ever find someone guilty of a DWI? We didn't have these kind of stuff. So they just used common sense. Whether there was video, whether there was not, whether there were people testifying, when you hear someone, whether they're in outer space or not. Just use common sense. Please.
Thank you, Judge. All right, let's move on. Okay, let's talk about witness credibility. So, in the state of Texas, right, no matter what someone looks like when they walk through that door back there and get up on the stand, they all start at the same level, right? Doesn't matter if it's the Joker, Bruce Wayne,